Good afternoon, all the viewers of Gyan Darshan, and welcome to this joint effort of IBBI and IGNOU for doing the advocacy of the provisions of Insolvency and Bankruptcy Code and creating the awareness amongst the stakeholders about the provisions of the code and how these provisions of the code can be utilized for the purposes of taking advantage of the various provisions of the code. Actually, the viewers, since the time this legislation has come, my practical experience is that the number of defaults in the Indian economy and in the Indian corporate sector have come down drastically. And actually that has been the objective of this legislation, that there should not be any default, and in case there is a default, in such cases there are recourses available to the stakeholders to file applications to initiate actions against the defaulters. As number of webinars have already happened under this legislation in this joint program, all of you viewers must be knowing that under this legislation, three kinds of applications can be filed. One under section 7, that application by the financial creditor, that in case there is a default by the corporate debtor, the company with its financial creditors. Second application is under section 9 of the code, and this application can be filed by the operational creditor. And the third kind of application which can be filed under the code is under section 10, which can be filed by the corporate debtor itself. Dear viewers, I'll be confining myself to this application which is to be filed by operational creditors under section 9 of the code. Now, before this application is filed, we need to understand that under what circumstances this application under section 9 can be filed. Who is an operational creditor and what is an operational debt? What is the meaning of the word default and what is the meaning of the term dispute? First of all, I will come to the definitions of these terms, the operational creditor and operational default. Operational creditor under the code, the viewer, has been defined as a person to whom an operational debt is owed, legally assigned or transferred. Which means if there is an entity, a company, which owes money to its operational creditors and some operational debt is owed to them. So these creditors to whom this operational debt is owed are called operational creditors. But before we understand who is operational creditor, what is this operational debt which is owed to this operational creditor? The legislation defines the term operational debt also. And it says operational debt means a claim. It means a claim in respect of provision of goods or services, including employment, or the debts owed to central government, state government, or any local authority. In the next slide, I have actually discussed in detail how this operational debt can be defined or understood. It means a claim. Operational debt means a claim in respect of provision of goods or services. Suppose I am a manufacturer of goods and I have supplied certain goods to a company, say ABC Limited. Now, the moment I supply these goods to ABC Limited, whatever ABC Limited owes to me against the supply of these goods, it is an operational debt. The second, claim in respect of provision of services. Suppose I am a supplier or provider of certain services. I don't manufacture any good, but I am a provider of services. The moment I provide certain services to a company, this suppose the same ABC Limited, the moment these services are provided and some amount is due against these services by this company to me, this amount which is owed by this company to me is called an operational debt. The third operational debt is claim in respect of provision of employment. Suppose a company is having number of employees and workers. So anything and everything which is payable to these employees or the workers by virtue of the contract of this employment under the service agreement, these outstanding amounts are also operational debt, which means any employee or worker to whom this amount is owed, and if this amount which is owed, if the total default amounts crosses the threshold limit, I'll discuss with you the threshold limits also. If this amount crosses the threshold limit, then these employees or the workers can also file an application under Section 9 against this company. So this is also an operational debt. And the fourth debt, which has been defined under the code, is debt in respect of payments due to the government or the local authority. So all these statutory dues, whether they are tax dues or other outstanding dues, which are payable to the state government or any local authority, these dues are also called operational debt. So in short, four types of debts are called operational debts. Debt to be paid against the purchase of services, purchase of goods. Debts which are outstanding for the purpose of availing the services. Debts which are due to the employees or the workers, and the debts which are due to the government, which is called statutory dues. These are not loans to the government. If there is a loan to the government, loan payable to the government, that will fall under the definition of financial debt. But these are all other outstanding dues to the government, maybe tax dues or other dues. These are called government dues or statutory dues, and they are also operational debt. A long debate has happened during last 5 years since the time this legislation has come. What will happen to the security deposits or advances given to a company? Actually, all these security deposits and advances do not fall within the definition of operational debt. However, recently, Supreme Court in the case of Consolidated Construction Limited versus Heathrow Energy Solutions has decided, and this is a landmark judgment. This judgment has been pronounced only on 4th of February 2022. Where there it has been held that debt arising out of advance payment of supply of goods or services is an operational debt. Now suppose I am a company and I have to purchase certain goods from somebody. Now that particular supplier has deposited certain money with me, or has given some advances with me, or has deposited some security with me. Now, if I do not supply the goods, or I do not refund this money to that purchaser, so that purchaser, by virtue of this advance given to me, also become an operational creditor by virtue of this landmark judgment. This is a very, very welcome change, very, very welcome amendment. No, not amendment, rather I'll say amendment through this judgment. Supreme Court has actually cleared the way. Now, number of those depositors or those entities which were paying certain advances to many companies, now all those purchasers, all those depositors can be termed as operational creditors now, because this particular amount of advance can now be called as operational debt. Now I come to the definition of the term debt and definition of the term default. As we all know by now, that to file an application under Section 7 or under Section 9 or under Section 10, first of all we have to establish two things. Number one, that there is a debt, and number two, there is a default. The moment the debt is established, the default is established, an application can be filed for this default amount. Now, what is the default amount? As per Section 4 of the code, till 24th of March 2020, this default amount threshold limit was just 1 lakh of rupees. That if there is any default amount of 1 lakh and above, an application under Section or under Section 9 can be filed against the company. But with effect from 24th of March 2020, the threshold limit of 1 lakh has been increased to 1 crore of rupees by virtue of issuance of a notification by the central government under Section 4 of the code. Now an application under Section or Section 9 can be filed only when the default amount is minimum rupees 1 crore. If there is any amount of default which is less than rupees 1 crore, no application under Section or under Section 9 can be filed. So, For filing an application in case of operational debt of operational creditor, the operational creditor has to establish that the total outstanding amount by the company to this operational creditor is not less than 1 crore of rupees. So there is a debt which is not less than 1 crore, only then this application under section 9 can be filed. Now many a times the questions arise that while calculating this amount of operational debt of rupees, default of rupees 1 crore rupees, can interest which is outstanding on this operational debt be added to this limit, to add it to this default amount to make it eligible amount to file an application under section 9 of the code. Recently, in this judgment of CBRE South Asia Private Limited versus United Concept Solution and Solutions Private Limited, it has been decided by our own adjudicating authority NCLT New Delhi bench that while calculating this default amount of rupees 1 crore, interest cannot be added to this. Suppose the total operational debt due is 80 lakhs of rupees and it has not been paid, say, for last 5 years. Number of reminders have been given. Now on this 80 lakhs, the total interest which has accrued for the purposes of calculating the default amount as per the operational creditor, he says that interest amount which is outstanding against this 80 lakhs is, say, another 50 lakhs of rupees. So the total outstanding amount as per the operational creditor is rupees 1 crore 30 lakhs, 130 lakhs. Now he files an application under section 9 of the code. The total default amount is 130 lakhs. But as per the company, the corporate debtor, it is only 80 lakhs which is the principal amount of operational debt, while 50 lakhs is on account of interest, and this interest cannot be added back to the amount of the operational debt to make it 1 crore plus. NCLT has decided that whatever interest has accrued on this operational debt, this interest portion is a financial debt. This is not operational debt. Therefore, for the purposes of filing an application under section 9 of the code, both the amounts, this financial debt and operational debt, cannot be clubbed together to make it a threshold limit of 1 crore and above to file an application. Therefore, an application which was filed in this case was rejected on the ground that financial debt or the interest portion cannot be added back to the original principal amount of operational debt to make it 1 crore plus. So dear viewers, whenever if you are an operational creditor, if you are filing an application, you need to ensure that whenever this application is filed, you must see what exactly is the default amount. This default amount should not include the interest portion. If the original operational debt is over and above 1 crore of rupees, and not the original debt but the original default amount. Suppose the total outstanding is 2 crores of rupees, but out of 2 crores of rupees, only the default amount is rupees 70 lakhs. Rest 1 crore 30 lakhs is payable later on. So whatever is payable later on does not become part of the default amount. Whatever amount is due and payable is actually the default amount. So if the default amount is over and above 1 crore rupees, only then this application under section 9 can be filed. So now these two things are clear to us. That is, one is debt, another is default. And these two, existence of these two is required under any application to be filed, whether section 7 or section 9 or section 10. However, under section 9, one more thing is required, which is not there under section 9, 7 or section 10. But this is applicable only in case of section 9 application, that whatever default is there, it should be there without any dispute between the parties. So for this purpose, we need to understand now what actually is dispute. As per the definition given under the code, it says dispute includes. Now it does not say dispute means. Dear viewers, whenever we read any definition under any law, we must see whether it uses the word means or it uses the word includes. If it uses the word means, it means it's an exhaustive definition. If it uses the term includes, it means it is an inclusive definition. Anything and everything which is not covered here may also be included later on in the definition. So here the definition of dispute, actually it starts with the word includes. It says dispute includes a suit or arbitration proceedings relating to what? The existence of the amount of debt, or the dispute with respect to quality of goods or services, or dispute with respect to breach of representation or warranty. So if any of these three is existing, or any suit or any arbitration proceedings has been initiated with respect to the existence of a debt, or quality of goods or services, or the warranties or representation with respect to this provision of services or supply of goods or services, then certainly it is a dispute. But it's not that easy the way it has been defined. Number of judicial pronouncements have been there, including the Supreme Court judgment in case of Kirusa versus Mobilox. I'll come to that judgment in a short while from now. Now, the moment there is a default, what will happen first of all? How the proceedings under the code are initiated by the operational creditor? Can he simply go to the court, that is adjudicating authority, NCLT, and file an application? Answer is no. In case of section 7, straight away an application can be filed by the financial creditor. In case of section 10, straight away an application can be preferred by the corporate debtor itself. But whenever there is an operational debt or operational creditor, the application cannot be filed straight away. First of all, this operational creditor has to issue a demand notice under section 8 of the code. This demand notice will clearly establish that there is a debt and there is a default. The details of the debt shall be given, the details of the default shall be given. And it says the CD, after receipt of this demand notice now the operational creditor issued a demand notice. It's not a legal notice. Let's be very clear. It's not a legal notice which is to be issued by your lawyer. But yes, this demand notice can now be issued by a lawyer also, provided the lawyer has been authorized by the company to issue. Not by the company, but this operational creditor, provided the lawyer has been authorized by the operational creditor to issue this demand notice specifically under section 8 of the code. Then only this lawyer can issue a demand notice. Otherwise, this notice has to be issued by the operational creditor itself. Now, after receipt of the notice, when this notice is received by the corporate debtor, within 10 days, 10 days time period, 10 days window is given. Within the 10 days, the corporate debtor will bring to the notice of the operational creditor what? That you have issued me notice to me. You are asking this money. But Mr. Operational Creditor, please see, there is a dispute which is already existing. And dispute has already been communicated to you also. These two things are required. Number one, that a dispute existed before receipt of the demand notice. And not only this dispute existed, but this dispute was communicated to you also. But you have failed to take cognizance of this communication of the dispute and you have issued a demand notice to me. Therefore, because this dispute existed, dispute stands communicated to you, this demand notice is bad in law. I am not taking cognizance of this. So, Mr. Operational Creditor, you cannot file any application against me under section 9 of the code. Please withdraw your demand notice. This communication should be there. Or, if no dispute is there, then within these 10 days, the corporate debtor may make a payment of this operational debt to the operational creditor and can communicate to the operational creditor that the payment now already stands paid and here is the proof of my payment. The third alternate is, if the corporate debtor is of the view that payment was already made by the corporate debtor to the operational creditor, but incidentally the operational creditor has not taken into consideration the payment which was already made to the operational creditor. So there in that case, a communication may be given during these 10 days by the corporate debtor to the operational creditor that payment has already been made to you, but you have failed to take into consideration that payment made. And here is the proof of that payment. and nothing is outstanding from my side to you. So this 10 days window is there. Now after the receipt expiry of 10 days, if the operational creditor is not satisfied with the reply given by this corporate debtor, operational creditor can still file an application under section 9. So existence of a dispute is a prerequisite if the corporate debtor wants to challenge this demand notice that this amount is not due. Now, how this dispute has been taken care of by various judicial pronouncements. This is one of such cases. I think maybe the top 5 cases in the country under section 9 with respect to the dispute. The two entities EPIL and MCL are involved in this case. Here, various invoices were raised for the purposes of construction activities. And these invoices was raised way back in November 2014. At that time, IBC was not there. So these invoices were raised in November 2014. Payment was not made. After that, number of reminders were given, but the company did not make the payment. MCL did not make the payment to EPIL. And no dispute was also raised. No communication was there. Ultimately, what happened when this legislation became effective on 1st of December 2016, MCL issued a demand notice under IBC in January 2017. Now at this stage, when the demand notice is issued, the company, the corporate debtor, raises various disputes that you did not do the construction work on time or the construction quality was bad. Matter went to the court. Court said, you have raised the dispute only after receipt of the demand notice, and this is not the appropriate time to raise the dispute. If there was any dispute, the dispute should have been raised before issuing of the demand notice. The services were provided to you way back in maybe 2014. Invoices were raised. Reminders were given. During that time, number one, you failed to make the payment. Number two, you failed to raise any dispute at that point of time. So, Mr. Corporate Debtor, at this stage, once you receive the demand notice, you cannot raise any dispute at this stage. Therefore, all your averments are rejected, and your application which has been filed against you shall be admitted. This is a landmark judgment of Mobilox Innovations versus Kirusa Software. Landmark judgment on this issue. I would like to read it from the slide. It says, while examining an application under section 9 of the code, the adjudicating authority first of all will have to determine what? Whether there is operational debt, whether the documentary evidences furnished by the application shows that the aforesaid debt is due and payable, and whether there is existence of dispute between the parties or the record of the pendency of any suit or arbitration, which also means a dispute. If it can be established, application will be admitted. If it cannot be established, application will not be admitted. This next slide is very, very important to understand this entire concept of dispute and existence of dispute. It says, para 40 of this judgment is very important. It says, it's clear therefore that once the operational creditor has filed an application which is otherwise complete, the adjudicating authority must reject the application under section 9 if notice of dispute has been received by the operational creditor, or there is a record of dispute in the information utility. It is clear such notice must bring to the notice of the operational creditor the existence of a dispute or the fact that a suit or arbitration proceeding relating to a dispute is pending between the parties. The bold portion on this screen, friends, is very, very relevant. It says, the court does not need to be satisfied that a defense is likely to succeed. The court does not at this stage examine the merits of the dispute except to the extent indicated above. So long as a dispute truly exists in fact and is not spurious, hypothetical, or illusory, the adjudicating authority has to reject the application. I'll just give you an example to make this very, very easy to understand all this. Suppose an order has been given on the basis of samples and the goods have been supplied. But the corporate debtor says that the goods which have been supplied are not as per order. Now at what stage he has said it? Suppose the goods were supplied, goods were used, and when the goods were used, after that payment is not made. Now the supplier says, make me the payment. Corporate debtor says, sorry, the goods were not as per sample. Now at this stage this dispute has been raised. When he is asking for the payment, he says, okay, you refund me my material. Material is also not refunded. So in this case, this dispute has been raised by the corporate debtor only with an intention of not making the payment. So where in this case, the dispute has been raised, dispute is spurious. Dispute is mischievous. Dispute has been raised with a malified intention only, so such a dispute shall not be taken into consideration by the court, and the court will decide that this dispute, though the dispute is there, existence of the dispute is there, but the dispute has been raised with a malified intention, so we are not taking the dispute into consideration. The application under section 9 shall be admitted by the adjudicating authority. Now, while this application is filed, what is to be observed by the adjudicating authority? Whether a demand notice was sent or not. If demand notice was sent, was it properly delivered? Whether 10 days time was given. Whether any dispute was raised within this 10 days. And if a dispute was raised within 10 days, what exactly is written in that reply? So the applicant, while filing this application under section 9 of the code, has to give an affidavit with respect to this, whether the corporate debtor has actually raised a dispute or not, whether he responded to the demand notice or not. And along with this, if available, a proof from the bankers of the operational creditor whether payment from the corporate debtor was received or not. Earlier, this certificate from the banker was mandatory, but with effect from 2018 amendment, the word if available has been added. It means if it is available, you annex it. If the proof is not available with the bankers, please do not annex it. So once this application is filed, application is annexed with an affidavit, demand notice is there, reply to the demand notice is there, proof of bankers if available is there. Along with this, the operational creditor, while filing the application, may propose the name of an insolvency professional to be appointed as interim resolution professional. This is the only section 9 of the code, where proposing the name of insolvency professional is not mandatory. Under section 7 it is mandatory, under section 10 it is mandatory, but under section 9 of the code, proposing the name of an IP is not mandatory. So once this application is filed, because I know a lawyer how the court takes care of this, once an application is filed, along with this application, a fee of rupees 2,000. Yes, 2,000 is there where that shall be deposited. Court will issue a notice to the corporate debtor after receiving a reply from the corporate debtor. If the court is satisfied, yes, there is a debt, there is a default of over 1 crore of rupees. Demand notice was issued. Reply has been received, but the reply does not demonstrate existence of a genuine dispute. Name of IRP has been proposed. Court is satisfied and court will admit this application, and the moment this application is admitted, this is the commencement of CIRP against the corporate debtor by the operational creditor. Actually, dear viewers, this is a legislation for the purposes of resolution of insolvency of the corporate debtor. But in majority of the cases, what we see that this legislation is being used as a arm twisting legislation, as a recovery legislation, and that has not been the intention of the legislation. This is not a recovery legislation. This is a resolution of insolvency legislation. The moment if some operational creditor uses this legislation is recovery legislation, this application may not be accepted. Though you might be complying with the law, but this application will not be admitted if this is used as a recovery legislation. In number of cases, it has been seen that operational creditor files an application is admitted, but later on it does not file his claim. In that case, it is treated as a malicious application, and any party who files a malicious application can be punished under the law. Now, at the end, I would like to conclude that once this application is admitted, there are many rights which are available to this operational creditor. One right is to receive a notice of the meeting, committee of creditors meeting, and attend the meeting, provided this amount of outstanding to the operational creditor is 10% of the total admitted debt. Second is, the government in 2018, the government has provided that operational creditor is entitled to receive payment in priority to other creditors in case there is a resolution plan. And number 3, the last right is to receive the liquidation value, if any, available to this resolution, to this operational creditor under the resolution plan. But actually, practically speaking, in almost all the cases, operational creditor is actually not getting anything out of the resolution plan. And in some cases, what they are getting is only 5% or 10% of their admitted claims. But once this notice is issued under Section 8, there are thousands of cases that operational creditor is receiving is his money. Therefore, the benefit of this legislation is that slowly and gradually the defaults towards the operational creditor are reducing, and even if there is a default, the moment this demand notice is issued, they are able to recover their money. So to that extent, this legislation is a major relief to the operational creditors, that there are no defaults, or defaults are there, the recoveries are there. So friends, dear viewers, the moment there are defaults, please ensure that you are filing this application by following the exact process as I discussed with you under Section 8 and Section 9 of the code. So wish you all a very best, and I hope you will use the benefit of the provisions of the legislation not for the recovery but for the resolution of insolvency of the corporate debtor. Thank you very much. Thank you.